Hey everybody, this is Edward and welcome to this advanced series episode, and today we are going to feature the case Shaheen versus Knight. And again, the focus here will be to examine what this case has to do with your law school exam so that you can speak intelligently with your professor and with your peers. So let's get to it. Now let's look at a general overview and see what this case has to do with your exam. So here are some general issues, and again we will answer these issues further below, and we will give you the terms of art that you need. It is very important that you understand the main headings here and the issues and see how they interact with each other. And once you do that, and then everything here makes complete sense. So let's look at the main headings here. So the contract formation stage, that's one of the principal headings, and we are under offer. And the issue is this: can a doctor enter into an agreement with the patient where the outcome may give rise to a cause of action under breach of contract as opposed to malpractice, which is of course under negligence? And also another main heading here is remedies. What are the results of having alleged damages that violate public policy? So let's go ahead and look at the main headings. Again, applicable law. This case right here is going to involve more than one main heading, where we talked about the contract formation stage, and it's also going to involve breach and of course remedies. Let's talk a bit further about that. So applicable law under the common law, contract formation stage under the offer, and here it is: a doctor can contract with the patient to form an agreement that may result in a cause of action on the breach. So a plaintiff there is not limited to bringing the suit just under malpractice. And there was no issue here as to acceptance because it was proper and they did have mutual assent. And of course, breach did take place. Why? Because there was a child born after the plaintiff contracted for a sterilization procedure. Remedies, the damages there. So notice that there was a valid contract that was formed, offer acceptance was met, and then you had a breach. So in a normal course, you would have had remedies that were available, but here notice that the damages that were alleged were contrary to public policy considerations. So that was fatal to the plaintiff's case. Let's go ahead and look at some key notes from this case. The issue we already discussed, and also the holding here is under section 6 of this text. So the defendant did make several arguments in its defense, and let's look at the important ones here. And number one, they alleged that a contract to sterilize a man violated public policy, and the court said no, there's precedent to that, so that wasn't valid. And then another argument of the defense was that there is no warranty of cure by a physician. And what does that even mean? Now that means that a warranty of cure is usually an implied warranty of cure, and that falls under negligence, under suit of malpractice. But here, the court said, look, the plaintiff is not alleging malpractice, they're specifically alleging breach of contract, so that wasn't valid. And I'm going to just refer to this as main heading 2, because a large part of the defense's argument falls under the content here. Okay, you'll see what I mean by that. And number 3, again, malpractice and negligence, refer to heading 2. We just talked about that. The cause of action is entirely separate from malpractice because here the plaintiff is alleging breach of contract. And number 4, he seemed to have some kind of misrepresentation there by the defendant, and the court says no. It seems as if the plaintiff did not even allege misrepresentation in its pleading. Number 5, skill and care, that sounds like negligence, and of course referred to heading number 2. And number 6, the sixth offense here, says that the plaintiff suffered no damages, and the court there said you might have a point there, and it does seem as if the alleged damages there are contrary to public policy considerations. So that was favorable to the defendant. But also, again, notice that you did have an offer and you did have a breach, but as far as the damages they were not available to the plaintiff. Let's go to the holding for the exam purposes. And holding 1, okay, we already talked about this, so you can read it in the book, which is in the description below. And holding number 2, again, damages, they cannot be contrary to public policy. And let's translate this into exam language, because this is really the takeaway. This is what you want to have when you consider an offer. Again, a doctor can enter into an agreement with the patient to form a contract that may give rise to a cause of action under breach. Now, again, we are under the offer, and again, notice that this is the contract formation stage. And then we go to the remedy stage, damages. To be awarded damages, they must not be contrary to public policy. And that is it for this case. I hope this helped. Until soon.